All right, we're looking at the certification of conductor final rule. We're on part H. The FRA solicited comments whether to require each railroad to provide the continuation education certificate certified conductors in Statute 242-119-0. Since the FRA did not receive any comments on the issue, because the FRA sees no reason to change its approach, the proposed continuation educational requirement contained in the notice of the provision railroad provision rulemaking. See the SF 75 FR 69-166, 69-176, 69-177, 69-204, and 2-205. November 10th, 2010 will be adopted in the final rule. The NYMTA and the SEPTA and AAR commented on the proposed language in the statute 242-119-D1, specifying the developed task analysis should be removed in the working group of the meetings preamble. The notice of provisional rulemaking FRA indicated to the extent of the proposed appropriate and to conform to the training requirements in Part 242 of the training requirements being developed in the Railroad Safety Advisory Committee of the Training Standard Plans Working Group. Because the Railroad Safety Advisory Committee recommendation of training standards and plans working group did not require the track task analysis, the FRA believes more of the comprehensive on-the-job requirement, including the final Rule C section on the section analysis of 242-119 adequate substitution attack analysis requirement. The FRA has removed the proposed task analysis requirement of the final rule. The NYMTA, SBTA, AAR commented on the FRA should remove the paragraphs 1 and 1 L and M to the proposed 242-119, the notice provision rulemaking. The paragraph proposed to require the railroads to perform initial instruction briefings with their conductors in the working group meetings. The preamble to the notice provision rulemaking, the FRA indicated the extent of the possible appropriate and would conform to the training requirements of Part 242 training requirements developed the Railroad Safety Advisory Committee, the Training Standards and Plans Working Group because the Railroad Safety Advisory Committee recommendation, the Training Standards and Planning Working Group did not require the initial instruction briefings. The FRA believes that initial training program requirements, including the final Rule C section by section analysis of 242-119 below, adequately cover the requirements of proposed paragraph. At the issue, the FRA has removed the paragraph L and M and has proposed the 242-119 of the National Notice of the Provisional Rulemaking for the final rule. The Brotherhood of Locomotive Engineering Trained Men commented on the 242-119 of the providing the exception initial briefing requirements of the 119 L and M should be deleted and replaced entirely with the following: initial training should be conducted within accordance with the requirements of Part 243. Since the FRA has not been issued an NPR relating to 243, the FRA cannot be the Brotherhood of Locomotive Engineering Trainmen, the U2U proposed language. However, the SRA, the Railroad Safety Advisory Committee Training Standards Plan of the Work Group, with the recommendation of the FRA does not require the initial instruction briefing. The FRA believes the initial program requirements that include the final rule. See the section and by section analysis of 242-119 below are adequately cover the substance of proposed paragraph at the end. The Federal Railroad Administration removed the paragraph N and proposed 242-119 of the notice of the provision rulemaking from final rule. L. Knowledge testing. The SPTA commented on the pros of 242-121C4V, which requires testing on the use of the job aid. Should be deleted. The section includes the requirements of the examination operating rules, timetable, instructions, which be presumably distributed with the individual's ability to use of the documents. The FRA believes in the important safety measures to ensure the conductor to be able to be used as any job aid defined by this part, but may be given, and moreover, the FRA does not believe that the testing operating rules, timetable, instructions when necessary to demonstrate the individual's ability to use a job aid. According to the FRA, declines the 242-121C4V as proposed notice provision rulemaking. The Brotherhood of Locomotive Engineering Trainmen commented, and the U2U commented on the 242-124C6 on the notice of provision rulemaking would have the required knowledge to be conducted without open reference book other than materials except for the degree of the person when it is being tested on his or her ability. Such reference books or materials should be deleted. While one would be expected the conductor to refer to his or her written rules instructions whenever there is an unnecessary about of the required particular rule instruction practices, the FRA believes that some of the rules fundamental railroad safety, such as compliance with the stops, the signals, and the conductor will be expected to know the rule with the referencing of the reference material. Referring to the reference material. According to the FRA, declines to delete the 242-121C6 proposed by the notice of provision rulemaking. J. Monitoring operational performance. The NYMTA seeks the confirmation the training may be used to substitute to satisfy the annual unannounced test of the unannounced test of the person certified by the passenger conductor is pursuant to Section 242-107B2, who do not require the compliance with the Part 218 Subpart F, except under emergency circumstances. The FRA confirms the training may be used to substitute the pursuant to 242-123D2I. The SPTA and the NYMTA commented that not feasible to the test each of the certified conductors on one or more of the provisions of Title 49, 218.99 to 218.109 because of the majority of the passenger conductors do not have the opportunity to perform 218 tasks on the regular basis. The SPPTA recommends that 242.123 D2I to allow the annual substitute for the annual test of the passenger conductors. The FRA declines the NYMTA SEPTA comments on this final rule. The FRA believes that 242.123 D2I addresses the SEPTA NYMTA concerns of the passenger conductors who engage in activities covered by the part of the 218 subpart F. The FRA accepts the passenger conductors will not have to engage the activities covered by the part 218 of the subpart F, which the FRA means with the phrase that compliance with the Part 218 subpart F excepts in the emergency circumstances. Accordingly, the FRA accepts for the passenger conductors will be permitted to give an annual training in lieu of the unannounced compliance with the test. With no revision of the 242.123 D2I, based on the comment of the FRA is revising the paragraph to clarify its intent. The FRA intended the 242.123 D2I to state that the annual training exceptions only applies to the part of 218 subpart 5. Subpart F testing and the railroad still will have the test of 217. The final rule would be revised and accordingly. The SPTA and NYMTA commented with the time limit proposed in 24123. The 242.123B1 and through and F, the testing conductors returning to the service should be extended from 30 days to 60 days. The contendant would also provide an increase in the quality of observation with the following of the managing extra opportunities observing the employees different the job assignments as provided with the preamble of the notice of provisional rulemaking proposed by the B1 and the F. B1 1 and F address the problem with the certified conductors may not perform and service the requires conductors. Thus, the railroad may not apply with the revised conductors with annual and unannounced compliance tests. Unlike Part 240, which requires railroads to seek the waiver of the FRA safety boards for the engineering, with the unable to annually test, the proposed paragraph would not require the railroads to give an unannounced compliance test to the conductors who are not performing service requiring certification. Moreover, the railroads were given in approximately a month or a test of these conductors returning to the service. The Brotherhood of Locomotive Engineering Trainmen commented, and the UTU commented that the rules should be make it clear that the employee make the work of the 30 days pending of the unannounced test, thus asserted by the 242.123F, which should be amended as follows. However, whenever the certified conductor returns to the service that requires certification pursuant to this part, the certified conductor shall not be deemed ineligible, but must be tested pursuant to Section 30 within 30 days of his or her return. Emphasized added, the FRA declines to adopt the revision suggested in this comment just as the locomotive engineers and under the Part 240 to the failure conduct on the unannounced test of the does not affect the conductor certification or railroad failures to the given the test of the person to not be rendered ineligible to serve as a conductor. However, this does not mean when it would not be eligible for any other person. For the example, the conductor to determine the active substance abuse disorder would ineligible to serve as a conductor regardless whether the conductor had received an unannounced compliance test within 30 days of his or her return of the conductor service. Since Brotherhood of Locomotive Engineering Trainmen, the UTU provides revisions could be read to prevent the railroad from deeming a person ineligible for any reason under the person returning the conductor service. For the FRA declines to adopt the revision. K. The time limitation for certification. The Brotherhood of Locomotive Engineering Trainmen and the UTU commented on the conductor certification rules should be consistent with the potential medical standards being considered by the FRA. The FRA exemptions were not, where possible and appropriate for the 242, with consistent with any potential medical standard rulemaking. The certificate components. The FRA certificate components. The FRA commented with required of the conductor certification include the physical description, photographer of the conductor, photograph of the conductor as stated with the notice of the provision rule making locomotive engineering certificate is required, but they include physical description of the photograph of the engineer pursuant to the Part 240. Moreover, the FRA believes the requirement would enable the FRA inspectors, railroad officers, police officers to quickly verify that the person in possession of the certificate and is in fact that person listed on the certificate. In Since the FRA does not receive any of the comments on the issue because the FRA believes it will assist in monitoring the railroad compliance with the certification of conductor, the proposed physical description photograph requirement of the notice provision rulemaking will be adopted in this final rule. M. Multiple certifications. The notice of the notice provision rulemaking, the FRA solicited comments regarding whether to add the provision statute 241-213 would require the railroad's determination of the certification to revoke when where a person was serving as both a conductor and engineering involved with the revocable event based on the work of the person who is performing at the time the conduct occurred. With the FRA is that such determination will be similar to one of those made under the 215F and under the 225, in which the railroad determined whether an accident would cause the poorly performing of the traditional considered conductor's job function, traditional considered the locomotive engineer job function, their own locomotive engineering trainman, and the UTU supported the additional provision with the AAR commented that the railroad should be able to revoke both certificates. The FRA has included the additional provision of the 214-213 final rule. The FRA believes that the provision is necessary but to bring an additional continuity to the revocation process. Moreover, the determination is not new to the railroads, as though ready them similar to determinations under the paragraph Part 225 agreed with the inclusion of the similar language of the 242-215 NPR. The FRA does not believe it necessary to revoke both certificates in situation because the certified as a conductor and engineer will not be permitted to serve either of the position. One certification has been revoked over any of the other part of the 218 subpart F. The revocation which respects to the 218 subpart F, the AAR recommended it not feasible since the Part 240 does not currently permit a person certified as an engineer to have as in here his or her engineering certification revoked with violation of Part 218 subpart F. The Amtrak's SPDA NYMTA commented on 242-13 proposed requirement of the locomotive engineer, including that the RSEO operating without an assigned certified conductor must be certified as both a locomotive engineer and a conductor, or be accompanied by the certified conductor who will attach to the crew. The manner is similar to the independent assignment. The Amtrak, the SPTA NYMTA comments asserted that the requirement should be amended to provide exemptions for the passenger railroad training operation in certain areas and contents. The Amtrak, the SPTA, NYMTA comments concern to verify the definition of a conductor. The definition will subject lengthily to discussion during the work group, and the meeting's recommendation of the work group was adopted by the notice of the provision railroad or so the rule making. The definition fundamental element of a conductor. Certification regulation of the FRA does not discern any of the safety railroad-related reasons to modify it. Moreover, the exemption is built with the final rule, which addresses some of the concerns raised in the comments. For example, if the conductor is removed from the train for a medical or police or other such emergency for the train departs and for an initial in-terminal, the train must proceed with the locomotive engineer and being certified conductor to first location where the conductor can be replaced without incurring undue delay. The interested parties should also note that the movement of the locomotive, which confines the locomotive repair and servicing area, moved at the locomotive less than 100 feet. Inspection of the maintenance purposes would require a certified conductor in accordance with the Amtrak's SPTA NYMTA comments adopted in this final. The Board of Locomotive Engineering Trainman commented that Statute 242-213H1 should be amended to make clear that both engineering and conductor certification are revoked for the different lengths of the time. Revocation period should run concurrently with the Brotherhood Locomotive Engineering Trainman and the UTU recommended amending the 242-213H1 and to read as follows: for the purpose of determining the period for which the person may not work as a certified locomotive engineering due to the revocation of his or her conductor certification, only violation of the 242-403E1 and E through E5 and or E12 will be counted. The person would hold the conductor's conductor locomotive engineering certificate who has had his and her conduct certification revoked 3 times in the last 36 months of the 2 violations of the 242-403E6 and 1 violation of 242 403E1 would have his or her conductor certificate revoked for 1 year, but would not be permitted to work on the locomotive engineering for at least first month of the revocation period for the period of the revocation for 1 violation of Statute 242-403E1. Emphasizes is added. The FRA declines to adopt the Brotherhood of Locomotive Engineering Trainmen of the UTU Amendment, Section 242-213H, and the Charter of the Appendix E already make clear that the period of the person cannot be working as an engineer during the period of the conductor's certification is revoked. The IE concurrently with moreover the FRA cannot say that the person in the example given in the statute 242-213H1 would not be permitted to work as an engineer for the first month of 1 year revocation period because of the example due to the provided that the exact order of the revocation. Nonetheless, the FRA intent for the period of the conductor could not work as the engineer would occur at the beginning of the revocation period. Thus, the person would hold the concurrent conductor of the locomotive engineering certificate who has had his or her conductor certification revoked twice within 24 months of the first violation of Statute 242-403E6 and the second violation of 242-203E1 would have his or her conductor certificate revoked for 6 months, but would not be permitted to work as a locomotive engineer for the first month of the 6-month revocation period, i.e. the period of the revocation for one violation of the statute 242-2403E1. And the territorial qualifications. Brother of locomotive engineering training trainmen or Teamsters commented on the provision of the proposed in 242.301 should be the amended the state of the person who assists the conductor lacking territorial qualification on the main track. Physical characteristics may not be assigned to the crew member. In support of this comment, the Brotherhood of Locomotive Engineering Trainmen of the UTU notes that under Part 242, the pilot who assists the locomotive engineering lacking the qualification physical characteristics of the territory may not be any assigned crew member that is the person for the proposed notice of the provision rulemaking of 242.301C would permit the locomotive engineering training man who is certified as a conductor qualified on the physical characteristics of the territory to assist the assigned conductor if the conductor lacks the qualification of the physical characteristics of the Brotherhood of Locomotive Engineering Trainmen. The UTU asserts that could lead to the situation in which the engineer would require to simultaneously perform safety critical responsibilities of the two people, including some of the may be performed in the two different physical locations. The AAR opposed to the BLE, the Brotherhood of Locomotive Engineering Trainmen, the UTU amendments. According to the AAR, proposed amendment ignores the distinction between the engineering duties, the conductor duties, and that of requiring the engineering to assist the conductor. The engineering can conduct a job safely briefly, provide the conductor with the information necessary to allow safe move. In addition, with the AAR asserts the lack of the need of the non-crew pilot is supported within the fact that the job aids may be used on the other main track where it is not practical to provide an assistant, whether an engineer is providing necessary information pertaining to the territory on the conductor with using the job aid. The conductor will have the sufficient information available to allow for the safe of the operation of the train. Based on the comments received after the further review of the issue, the FRA has revised the requirements of the statute 242.301. Regardless of the conductor lacking territorial qualification, the main track physical characteristics must be assisted by a person who meets those qualifications. The revisions derived in large part of the pilot requirements of the locomotive engineering Part 240. Provided differing requirements depending on whether the conductor has never been qualified as a main track physical characteristics of the territory over which he or she serves as conductor, whether the conductor was previously qualified on the main track physical characteristics of the territory over which he or she is to serve as a conductor, but whose qualification has expired. For a conductor who has never been qualified on a main track physical characteristic of the territory over which he or she is to serve conductor, the final rule requires that the assistant must be a person certified as a conductor meets the territorial qualification requirements for the main track. Physical characteristics is not an assigned crew member for the conductor who is previously qualified on the main track. Physical characteristics territory overview, which he or she is and served to the conductor with the qualification has expired. The final rule allows the assistant to be any of the person is assigned to the crew member other than the locomotive engineer, as long as the service the assistant would not conflict with the crew members other than safety sensitive duties who meets the territorial qualification requirements of the main track physical characteristics. In addition to the revision as to when the assistant is required on the main track, final rule includes the exceptions to the assistant that is not required on the main track. Those exemptions which are derived in Title 49 Part C Code Federal Regulation Part 242.31 C apply to the movements on the section of the main track of average grades less than 1% or other than 3 continuous miles and The maximum distance the locomotive train may be operated does not exceed 1 mile. 2. The maximum authorized speed for any other operation on the track does not exceed 20 miles per hour. 3. The operation of the conduct under the operating rules that the rail require every locomotive of the trainman to proceed at the speed permits stopping within 1.5 of the range of the division of locomotive engineer. The FRA believes that these changes will serve the interests in the safety and address the concern of the other locomotive engineering trainmen, provide flexibility for the railroad's handling situation, which requires an assistant, making this final rule more consistent with the main track of the pilot requirements in Part 240. The Brotherhood of Locomotive Engineering Trainmen and the UTU also commented that the proposed job aid provision in Statute 242.301 should be mandatory and suggest for the last sentence of the section should be read as, where not practicable, the conductor should provide an accurate job aid to provide the entering of the track. If it was FRA intent for the job aided the provision of the 242.301 be mandatory, it may be revised accordingly to the final rule. The FRA declines to adopt additional suggested revisions as believed that the phrase appropriate up to date used in the notice of the provision rule making encompasses the suggested accurate term accurate and the prior term entering to the track. Language is not necessary because the conductor who lacks territorial qualifications on the segment of the track will not be permitted to enter the track until they are aware and practicable, assisted with the certificate conductor who is qualified or approved of the appropriate up-to-date job. Denial of certification. In the notice of the provision rulemaking, the FRA solicited comments on whether to add the two provisions of Statute 242.401 CS 75 FR 69.166 and 69.181, November 10, 2010. The first provision provided with the added the following sentence of the paragraph A of the section of the railroad should provide the conductor candidate with any of the written documentation records, including the written statements, which support and pending the denial of the decision. The second provision provided with the add the following sentence paragraph of this section, the basis of the railroad denial of the decision should address any explanation, rebuttal information, but the conductor may and have the provided with the written pursuant to the second paragraph A of this section. The AAR commented on these that they opposed the first proposal that supporting the documentation could include the privileged documents and documents that will be used in litigation. As stated in the NPR, the intent of the first proposed provision is to improve the transparency of the certification denial process and approval of the FRA's ability to adjudicate the petition seeking the review of the railroad denial decision pursuant to subpart E of this rule. Denial decisions are not accompanied by the hearing of the transcript, often the little title or no documentary record. This issue of the FRA is trying to address the situation whether the conductor candidate does not get enough information regarding the denial of the situation draft an appropriate rebuttal. The FRA wants to avoid delay of the cost of the conductor candidate having to petition to the operating the crew review board to obtain documents. They may need a rebut of the denial decision if the conductor candidate are provided with the better information up front. The FRA expects the fewer petitions will be filed by the UCRB. The FRA is not requiring documentation regarding employment to the personal issues rather than the only interested documents related to the failure to meet the requirement of the Part 242. For example, the FRA would be expected the locomotive download printouts and Forms B and the transcript of the railroad communications that support the pending denial decisions would provide the conductor with the candidate under this following rule. The OCRB already has an authority to order railroad to produce through those documentations. The FRA would not expect that they would be privileged. According to the FRA, is adopting the first proposal with some modifications in this rule. Since the FRA did not receive any comments objecting to the second proposal provision, the FRA says no reason to change this approach. The second proposed provision will also be adopted in this final rule. In the notice of the rulemaking, the FRA also asked whether the intervening acts caused the exemption proposed paragraph D of the 242.401 should be modified to include the certification recertification requirements in addition with the revocable events of the statute 242.403. FRA provides an example of how the paragraph D could be modified. A railroad shall not be determined by the person failed to meet the eligibility requirements of this part, shall not deny the person's certification if sufficient evidence exists to establish that an intervening cause is prevented with the material impaired the conductor ability to comply with the railroad operating rules, practices, certification, recertification requirements, which the basis of denying the person certification, recertification. See SF 75 FR 69-166 and 69-181, November 10th, 2010. The AAR commented that they do not understand what the FRA trying to do, and stated that the FRA appeared to be contemplating that they could intervene in the event on which the basis of the denial of certification independent of the events listed in the statute set 242-403. The Brotherhood of Locomotive Engineering Trainmen of U2U agreed that the statute 242-401 should be modified as proposed by the FRA. Contrary to the American Railroad Association, the American Association of Railroad comment, the FRA is not suggesting that the intervening cause could serve as a basis for denial. Rather than the FRA proposes to provide an intervention cause that could serve as a basis not for denial of certification. At May 12th, the working group meeting, AAR stated that they were proposed extending the intervening cause of the provision denial certification. All that the meeting member of the working group expressed the concern of under the proposal is certain a conductor candidate who is not able to hold themselves up on the side of the car which in turn led to the violation of statute 242-403E1 or E11 could assert as an intervening cause in agreement. Because the proposed modification appears to has caused confusion, could lead to the unintended consequences of merely classify the FRA's existing authority. The FRA has decided not to modify the statute 242-401D as proposed in that notice of the provision rulemaking. Further, rather than the FRA has clarified that paragraph D in this final rule to reflect more accurately what is said to be the notice of the railroad notice rule-making provisions. Interested parties should note that, however, like the LERB under Part 240, the OCBRB has the authority, if petitioned, to review the basis for the denial and recertification of the railroad to determine if substantial evidence supports the decision. B. Criteria for revocation of certification. If in the notice of the provision rulemaking, FRA solicited comments whether the violation of the final rule of the Title 49 Code Regulation Part 220 restrictions railroad operating employees using cellular telephones or other electronic devices can constitute a revocable event of the conductors of locomotive engineering. In particular, FRA asked whether they should use its other enforceable tools, the EGR and monetary civil penalty of an individual liability disqualification, instead of mandating the revocation of how a railroad would acquire the necessary evidence to revoke the conductor or locomotive engineering certification. For the violation of the Title 49 CFR Part 220, the AAR SEPDA commented on the violation of the Part 220 should constitute the revocable event. The AAR stated that it would accept that the FRA would provide assistance and support necessary, including the invocation of the subpoena power when appropriate. Brotherhood of Locomotive Engineering Training Unit, the U2U, commented that they are opposed including the violation Part 220 as a revocable event under Part 240 and 242 because the FRA data shows that the cell phone violation is qualitatively different from the violation of those cardinal sins. There is no indication that there is a pattern of cell phone violation requiring imposition revocation. There are a number of the questions regarding the FRA data are unanswered. The FRA currently has sufficient tools at its disposal to subpoena individual liability to and to protect punishment violations. Alternatively, the Brotherhood Locomotive Engineering Training Union, commented on the FRA makes it a revocable offense that the regulation should be state that the revocation is appropriate only when electric devices are improperly used while performing safety-related duties and the use of contributed to the event of the identified in Statute 219-201. At this time, the FRA had decided not to include the Part 220 violation of revocable event in this final rule. The FRA also already has a new regulation in the Title 49 Code Regulation Part 220 to address the cell phone use and believes that the time should be allowed to study what the impact of the regulation on the improper use of electronic devices on the railroad. In addition, with the FRA numerous enforcement tools against the individuals and address the misuse of electronic devices, warning letters, civil penalties, disqualification, etc. Moreover, requiring revocation of Part 220 violations would be incredibly difficult for the railroad to enforce and apply. The FRA cannot legally use the subpoena powers to gather information from the railroad, which is the AAR accepts to happen. Therefore, the FRA expects that most cases would simply be one person's statement versus another. The railroad appears to have rules and policies in place that address the misuse of electronic devices. A survey in Class 1 railroads indicates that the general having the rules policies in effect with that are more comprehensive than the federal minimums contained in the Part 220. The discipline of noncompliance with the typical government with the specific nature of the offense discipline record of the employees ranging from the coaching and counseling and dismissal. Although the FRA is not included with the Part 220 violation of revocable events, the FRA will continue to monitor the use of electronic devices. If necessary, it will consider the amending of the regulation to include the misuse of such revocable event. Moreover, the FRA accepts the use of disqualification authority under the Part 211 instances where improper use of electronic devices is found under the Part 220. The FRA will be making a zero-tolerance review of such violation. In addition, with a civil penalty against the railroad will also utilize the disqualification authority against individual employees to extend the practicable in any such instances and misuse an employee. The NYMTA SEPTA commented that the conductor who is called to perform the duty of the train crew member other than that of the conductor of locomotive engineering should have his or her certification revoked based on the actions taken not taken while performing that duty. The suggestions, however, the runs countered with the statute 242-403 C3, where it was that agreed that the working group paragraph C3 of the section 242-403 states that the certified conductor who is called by a railroad to perform the duty of the train crew or train crew member other than the conductor of the locomotive shall not have his or her certification revoked based on the actions not taken while performing that duty. The FRA believes that the paragraph explains the status quo of the form of the approach to take in Part 240 of the locomotive engineer. See the 24117 C3 for FRA expects that the paragraph will help them keep down the number of the railroad hearings and petitions for the FRA. The review of the pursuant of the dispute, the resolution according with the FRA has adopted the paragraph of this final rule. The Brotherhood of Locomotive Engineering Trainmen, the U2U, commented on the explanation of the paraphrases appropriate action with the statute 242-403C and 242-403E2-1 should be amended with the state of the duty is met whether the duty may be met by warning the conductor of the engineering of a potential foreseeable violation. The FRA declines to adopt the change due to the fact that the appropriate action depends on the situation. For example, if the conductor provides a warning with plenty of a distance that the conductor has likely to meet his or her duty. However, the conductor of the train who provides the warning of the first time 1 second before the train passes the stop signal, if the conductor was aware of the 3 miles back likely to has not been meet his or her duty. The periods of ineligibility. NYMTA and the SPTA commented regarding the proposed statute 242-405-831. Which provides that only on the other main track when restricted speed of the operational equivalent there is in effect of the period of revocation of the violation of the statute 242-403 E6 or E8 or E10 or E11 shall be reduced on one by one half of the other revocable event that has not occurred within previous 12 months. The NYMTA commented that the FRA should leave the ability to assist the proper discipline for the speeding of the violations on or other mainline track which controlling railroad. The SPTA commented on the proposed statute 242-405-A31 should be eliminated because all the violations should be treated with consistently regardless of whether they occur as explained with the notice of the railroad provision of the statute 242-405-A31 recognize the same violations which occur on the other mainline track where the slower speeds are ineffectively likely to pose less of the danger safety of the violations that occur with the main track and thus reduces the period of revocation is warranted. Nothing in this comment submitted by the altered FRA views of this, and therefore the FRA has adopted the provisions proposed in this final rule. The SPTA commented that Title 242-405 should be changed to the periods of the revocation and denial certification consistent with their commented regarding the definition ineligible, and ineligibility. The FRA declines to adopt the SPTA's comment for the reason it has declined to adopt the comment regarding the definition of ineligible and eligibility. See the discussion of the definition of ineligibility, and the general summary of the comments and the final rule. In its comments, the SLRRA recommended an alternative procedure for the Class 3 railroads to address the situation where the disqualification conductor, which would result in the disruption of the service because there is no other available certified conductor's replacement in situation. ASLRRA ASLRRA suggests the decertified conductor on the Class 3 railroads would never previously been certified would be required to undergo remedial training and testing that would be allowed to continue the function of the railroad as conductor under specific restrictions to match, even triggering decertification. The FRA declines to adopt alternative procedures for Class 3 railroads because, one, the procedure will result in disparate the treatment of the conductors across the three classes of railroads, i.e. the conductor of a Class 1 railroad would not be permitted to serve as a conductor following with a decertifiable event, whereas a conductor in Class 3 railroad would also be involved in the same type of decertifiable event may be permitted to serve as a conductor. Two, there is no less safety risk if the person is a conductor for a Class 3 railroad as opposed for the conductor of a Class 1 or Class 2 railroad. The procedure appears to leave open the possibilities that the conductor is involved in revocable event on the Class 3 railroad could immediately go to work for the Class 1 railroad due to the fact that the restrictions were placed on the conductor's certificate rather than having the certificate revoked. R. Processes of revoking certification. The FRA solicited comments regarding the understood the proposed statute 242-407B4 and the notice of provision rulemaking. Pursuant to the proposed section, the railroad would, among the other things, provide the conductor subject the railroad revocation hearing with the list of witnesses the railroad would present at the hearing. The notice of provision railroad rulemaking noted the FRA understands the extent of the employee of the conveying of the railroad whose statements lead to the suspension under the statute 242-407B1. The railroad would not have all to call every witness and to put on its list. See the CF 75 FR 69 166 69 184 November 10, 2010. So the FRA did not receive any of the comment regarding the understanding. The FRA does not discover anything to its change understanding. The FRA adopts understanding as part of its final rule. The Brotherhood of Locomotive Engineering Trainmen in the UTU commented on the phrase of the just prior to the proposed in statute 242-47B4 is ambiguous and should be changed to definite time, i.e. 48 hours, and that telephonic testimony should be limited to general subject matter testimony. The FRA acknowledges just prior to somewhat of the ambiguous railroad needed the flexibility with the timing since the railroad does not also always have a copy of the written information, nor do they have known exactly who will serve the witness in 48 hours in advance. Although the FRA declines to adopt the comment, the FRA notices that the party to railroad hearing may ask for the recess if they do not believe that they have sufficient time to prepare the case. Moreover, the AOCRB, if position cannot consider the time of the party had to be prepare his or her defense in determining whether an appropriate defense was possible. The Brotherhood of Locomotive Engineering Trainmen in the UTU commented regarding telephonic testimony would narrow the scope of the proposed statute 242-407B4 in a manner not agreed with the working group and intended with the FRA for the intent of the section proposed in the NPR. The notice of revision rulemaking would allow the railroad telephonic exam an employee of the railroad whose statement, regardless of the subject formed on this formation, that the railroad would be present at the hearing, and if impracticable, to provide employee at the hearing. The section was narrowly tailored to note and one only an acknowledgement that it is important for the conductor in a railroad hearing to provide with this information for the railroad was present prior to the convening of the hearing, but also acknowledge that some of the impracticable provided with the witness at the hearing to retain the balance of the FRA is adopting statute 242-407B4 as proposed by the notice of the rulemaking making. Brotherhood of Locomotive Engineering Trainmen Union commented on the examples provided in the preamble to illustrate the term the minimal nature as proposed in statute 242-407I2 should be modified because they are not realistic. Although the FRA declines to modify the example provided in the NPRM, additional examples have been added to the section by analysis of the 242-407 in this rule. The FRA solicited the comment whether the railroad decision issued pursuant to the section proposed in 242-407C should include the following: state whether the railroad officially found the revocable event had occurred with the applicable period of the revocation of the citation of the stat. Article 49-242, the 405 periods of revocation contains an explanation of the factual findings, citations to applicable railroad rules and practices. Not to cite a railroad rule or practice that was not cited in the written notice of the suspension. Be served on the employees and employees' representative, if and any, with the railroad with retaining the proof of the service. The AAR commented with that there is no need for the third proposal. According to the AAR, at least one railroad labor agreements provided with the specific rule violation should not be cited in initial charge in a letter, and many other railroads have a long-standing practice that they are similar. A comment with the working group member also indicated that the rule cited would have to be changed if evidence developed as the railroad hearing required. Thus, in that instance, the railroad would need flexibility to cite a rule not cited in the written notice of the suspension. The AAR also commented on the fourth proposal unnecessary. As stated in the preamble of the notice of the provision rulemaking, the FRA proposed the language to ensure that clearly more detailed decisions are issued. Clearer and more detailed decisions would allow the conductor to understand exactly why his or her certification was revoked, would allow the OCRB to have more detailed understanding of the case, the exact as review the revocation decision pursuant to subpart E of this rule. Moreover, the service proposal would help them eliminate disputes as to whether the conductor was notified of the railroad decision. The FRA understands that the railroad may understand circumstances with the change of the ruling cited. According to the FRA, has adopted the first and second, final, and fourth, but not the third proposal in the final rule. However, the FRA is concerned about the conductors preparing the defense for the railroad hearing based on the rule cited in the written notice of suspension, only having the railroad change of the rule cited in the hearing during the hearing of the decision. Railroads must take actions to avoid this and should be grant a recess for the appropriate to allow the conductor to prepare the defense for the violation being cited. The railroad should also note that the OCRB may grant a petition to review the OCRB finding of the citing the different violation caused by the petitioner's substantial harm. The Brotherhood of Locomotive Engineering Trainmen and the UTU commented that the FRA must provide an immunity civil enforcement for the railroad that makes a good faith determination pursuant to 242.407 that the conductor certification should not be suspended, and the FRA BLETU UTU concerns that the strength of the preamble language in this final rule to address these concerns. Review Board.